Sharon Drexler. I'm here with an industry icon, a well-known attorney within the timeshare industry, John Rogers Burk, goes by the name of Roger, and he has a report on an interesting panel that he attended yesterday. So, Roger, perhaps you could tell us about that.
Thank you, Sharon. I attended the ARDA Business Models Forum here at the 2010 convention in Las Vegas. Howard Nussbaum, president of ARDA, asked a question, are we selling real estate or are we selling vacation experience? He then went on to ask the question, or to point out, that everything we do in this industry is like pulling a thread out of a suit. There are unintended consequences. Then he asked the telling question, salespeople tell us that to sell to Americans we have to sell a deed, but is that something we've just talked ourselves into? David Bidgood of Blue Green spoke right up and said yes, said when they stopped telling people they were getting a deed and they were selling beneficial interest in a trust anyway, he said sales were not hurt one bit. Bob Miller of Marriott points out that we are really selling vacation experience, that only in America do we think we have to sell deeds, and everywhere else we don't use deeds. Because again, he said, people are buying vacation experience. Rob Webb, Esquire, pointed out that in Florida they have written into their law in the definition of timeshare estate that it includes a trust interest or a beneficial interest in a trust which owns title to the real property. Lauren Gallagher of VRI pointed out that in the early days, lenders drove the timeshare legal structure because they only understood deeds and deeds of trust. And then he added, and perhaps we didn't trust our own product. One of the impediments to selling non-deeded timesharing has been a misquoting of the Windrifter tax ruling that came out about 30 years ago. It stands for the proposition that in a term membership, you have to recognize revenue as it is received. Now, a perpetual non-deeded timeshare wouldn't apply or wouldn't be subject to Windrifter anyway. But Windrifter has frequently been quoted as saying you have to recognize the entire sales price in the first year. Well, it happened in Windrifter. They received the entire sales price in the first year, but that's not the law of the ruling. Art Spalding of Cox Castle pointed out that to be properly structured, a non-deeded timeshare, the title to the property, the underlying real property, should be held by a trust or the association which exists for the benefit of the members. After the forum, Jim Marmistone of 10 Star came up to me and said, I was watching you through that whole discussion, and I could see how pleased you were that what you have promoted for 20 years is finally being endorsed by the industry. And then good friend Jeff Rose last evening, and Jeff has sold non-deeded for decades, told me that he has never lost a sale because he wasn't selling deeds. Now, my latest article on deeded timeshare consequences and remedies is in Resort Trades February edition. And you can read all my articles on my website at jrblawcorp.com. Thank you, Sharon.